Good afternoon, everybody. Thanks very much for attending today. My name's Fay Collinson. I'm barrister and mediator at King's Chambers, for those of you who don't know me. Today, I'm going to be speaking about a recent case in which I acted for the deputy. That case is a decision of Mr. Justice Hayden. I think it was handed down about a week or two ago. And it's the case of PSG Trust Corporation Limited and CK and NJ. PSG Trust Corporation was the deputy for two young ladies, both of whom are in their 20s. The first lady is CK and the second one is NJ. Dealing with CK first, she was a passenger in a really serious road traffic accident about 10 years ago. And as a result of that accident, she suffered very serious injury, including a brain injury. And a personal injury claim was brought on her behalf, which was ultimately compromised. NJ also suffered a brain injury and cerebral palsy, but in very different circumstances. She was the victim of a very serious shaking assault when she was only 3 months old. So a claim was brought on her behalf, which again was ultimately compromised. And the settlements led, as you would expect, to the appointment of a property and affairs deputy because the court found that both of them lacked capacity to manage their property and affairs. Many of you will know who are attending today that when a deputy is appointed for somebody like CK or NJ who has a very serious brain injury, there is this decision that has to be taken about whether they are told about the value of their settlement. Sometimes that's a really obvious decision and it's one that doesn't require much consideration. Sometimes it's much more challenging than that. And I've also seen cases, in fact, several cases, where that decision has already been taken prior to the deputy being appointed by P's clinicians or MDT, or even the solicitor acting in the civil litigation claim. In this case, we identified this problem in that there were various risks in telling CK and NJ about the value of their settlement. The judgment doesn't refer to the exact values, but by virtue of the extent of the injuries, they were significant. And the risks were several. The obvious one was financial and emotional exploitation. Both ladies had in some way experienced some form of financial exploitation, usually from boyfriends or family members. And so there was a real desire, certainly by CK's family, to protect her from further financial exploitation. But there were also other risks of telling these ladies. Would they use it as a way to sort of beat their care staff with a stick, so making demands of the deputies for certain things to be purchased for them. And so we identified those risks, but in the same vein, the deputy was acutely aware of their respective rights to autonomy and that it was a key piece of information that most people would want to know about. The deputy was also concerned that if either didn't have access to the information, then it may really affect or inhibit their ability to make other decisions. One example of those that we identified quite early on was about making a will. And I had been, when I was brought into this case, asked by several other deputies about this very issue, about how we reconcile the conflict between telling or not telling P about their estate, but also wanting to put them in their best position to be able to do something like make a relatively simple will. We also identified that there was a conflict in the way in which the experts had dealt with this issue in the civil claims. One of the expert reports had taken the view that if a deputy is appointed for P, there has already been a consideration about whether they should be told or not told, and it's really up to the deputy. So effectively saying, if they lack capacity to manage their property affairs, they therefore must lack capacity to decide whether they are told or not told about the information. And we didn't think that analysis was quite right. We also identified a problem with pre-existing authorities. We were able to find 3. I don't think there are any more. If there are, then me, Julian, and Hayden J missed them. But these are the key ones. 2 of them are from what was the Queen's Bench Division, and PBM is from the COP. And I'll just go through them very briefly to explain why we felt there was a problem with them. So the first one in the trilogy is EXB, and it was an approval hearing in a brain injury case under 2110. And EXB's mother and his civil litigation solicitor had both come to the view that it wasn't in his best interest to be told about the value of the estate for the reasons that were present in these 2 cases. EXB seemingly gave evidence at the approval hearing, and his evidence appeared to have been to the effect that he didn't want to know because he felt he would probably end up spending the money, and that also knowing about him having such a large amount of money would cause him additional stress. Hayden J put the issue in this way, that the primary question is whether I can conclude that the claimant cannot make for himself the decision about whether to be told the value of the award. And the key words there, I think, are to be told the value of the award. My instructing solicitor and I didn't think that quite encapsulated the test correctly. Because whether someone is told about the value of their estate really comes into the best interest decision. We felt that the test for the capacity, which is, of course, the first stage, the jurisdictional stage, should be termed in a different way, which is ultimately the way that Hayden J concluded it should be, which is whether P has the capacity to decide whether to request the information, not to be told. There is the 2 different things, and I'll explain why that is in a moment. The second case of PBM is from the COP, and this is a case that had a very different background. The issues were whether P lacked capacity to enter into a prenuptial agreement, and whether for the purposes of doing that, he should be informed about his estate. And so there was a question about how the court approaches that issue of capacity. In that case, I think David Rees acted for the official solicitor from memory. And his argument appeared to be, it wasn't a case I was involved in, but we saw the skeleton from that case because of this case. His approach appeared to be that the notion of asking a capacity question in this context is artificial. So their argument was that a capacitous person does not ask themselves whether they should be made aware of the extent of their assets. If they do not have the relevant knowledge to hand, they have a right to obtain that information should they wish to obtain it. So what was being said there is that there's no capacity decision to be made for P here. It's their information and they are automatically entitled to it. But we didn't think that was quite right, because whilst we accept that ordinarily someone is entitled to their information, they have to make a decision about whether they want to know about it. In the PSG judgment, Hayden referred to a number of examples that we provided to the court on how this works in practice. So, for example, during submissions, I gave the example of a care leaver who, when they turn 18, they might think, I'd quite like to see my local authority records. They have an automatic right to see those records once they turn 18. But there is a decision that they go through to decide whether they want to see them. And there may be a number of reasons why they don't. It might harm their relationship with their family or their foster family. And it might trigger historic traumas that they want to forget about. And ultimately, that individual may decide, I don't want to make this request. And similarly, you might have someone who is given a prognosis, a terminal diagnosis. That's information they're entitled to, but they may decide, I don't want to know what my prognosis is. And that I see that all the time in my probate cases where people actively take that decision not to request that information. So we felt that the approach in PVM, while sort of superficially attractive, so arguably specious, it wasn't necessarily the correct way of dealing with it. In that case, in PVM, the judge said, actually, it's being a bit border on semantic absurdity. And again, we felt that approach was incorrect because it ignored the approach of the Supreme Court in local authority in JB. And just by way of reminder, what that case says, or the sort of key principle to take away from that, is just the correct approach to capacity in the COP. So it's the first stage that you have to deal with is to think about the correct formulation of the matter in respect of which it is required to evaluate whether P is unable to make a decision. So in other words, what you've got to say is, what's the decision that P is being asked to make? I think that's probably a simpler way of putting it with respect to the Supreme Court. Once you've got that, then you move to the second stage, which is to say, what's the relevant information? So what information does P need to retain, understand, weigh up, etc., to make that decision? When you've got that, then you go to the causation aspect, which is to say, is P's inability to make that decision because of an impairment or disturbance of the mind? And the final case, go back to the High Court, is DXW. Again, it was an approval hearing, relatively large lump sum of 6.6 million. And in that case, Sinai J was asked to make an EXB order. So it sort of indicated to us that this was an issue that was cropping up at approval hearings where the High Court judge, who might not necessarily sit as a court of protection judge, was being asked to make decisions on P's behalf about whether they were told or not told about the value of their estate. And in that case, there was no reference to PBM, which again suggested to us that that hadn't been actively considered by the court in DXW. And again, it was a similar kind of scenario that the DXW's parents and his deputy and other experts felt that he lacked capacity to make a decision about whether he should know about his settlement. And the court concluded that he did on these bases. So the judge felt that DXW lacked insight into the need to keep the settlement confidential. So I suspect there might have been one of the confidentiality or autonomy clauses. Second, that the settlement was in respect of past and future losses, so principally in respect of care, case management and long-term assistance. And finally, the money could and should be used wisely and properly for his reasonable needs. When we looked at that case, prior to bringing the application, again, my instructing solicitor and I didn't agree with that because whilst there is a need to understand what the money is to be used for when you are considering P's property and affair capacity, you don't need to understand that to decide whether you request information. That's putting the bar far too high. And so we felt there that the relevant information that was being considered wasn't quite right. So we came away feeling that actually there really wasn't that much clarity or certainty from the existing authorities. The APG didn't have any guidance on it, and similarly there hadn't been from the senior judge any determination on this issue. So, and because of the risk to these ladies of them finding out, we brought this application seeking declarations on whether they lack capacity to request information about their settlement, and if they did, whether it was in their best interest to be provided with that information. And this is the way that Hayden framed the issues in the case. Firstly, he said, how should the capacity test be framed, where the focus of the concern is on P's vulnerability? And in these types of brain injury cases, usually that will be the real concern, that as a result of knowing about the settlement, that it will expose P to some realistic chance of financial or emotional exploitation. Secondly, should disclosure to P be regarded as automatic and as of right? In other words, is there actually a capacity decision that the COP needs to make, or is P just entitled to it anyway? And finally, is disclosure a facet of management of P's property and affairs? What he's saying there is there has been a deputy order made where the court has already declared that P lacks capacity to manage their property and affairs. So does this decision just come within that existing declaration that's been made by the court, or is there actually a separate capacity decision that needs to be considered? So I set out here the a summary of the court's decision. First, the judge agreed with our analysis that the capacity decision or question is not determined by the court's existing declaration that P lacks capacity to manage their property affairs. So what this means is that even though you are appointed as a deputy and the court has already declared that P lacks capacity to manage their property and affairs, it doesn't follow that P also lacks capacity to request information about their estate. And that is where, in my experience, some deputies have been going wrong, in that they have thought, well, I've got this order, therefore it's up to me about whether P is told or not. So if that is your experience in some cases, then it's probably sensible to go back and revisit that issue, and there will probably need to be a discrete capacity assessment on this decision. And what Hayden J then did was to set out what the relevant information was. And this was helpful because when we were instructing the experts, you often set out in the letter of instruction what is the relevant information, so that the expert can then go and discuss that with P and test their understanding and retention of it. So the relevant information that Hayden found was the way that we formulated it, which is in this way, that P needs to understand the nature of the information in question. So they do need to have a broad understanding of the settlement, or the ability to understand the settlement. So really figures, because there are some individuals with very extensive brain injuries who really do not understand numeracy and figures, as was the case with NJ here. There was evidence that if she went into a shop, she really struggled to understand values, whereas with CK, the position was very different. Then we move on to the various risks and benefits. So P has to understand the risks of having the information and the risks of not having the information, and the benefits of having it and the benefits of not obtaining it. So one thing that we discussed during the hearing was that P might, depending on the circumstances, need to have an understanding that if they didn't have this information available to them, it might make other decisions a bit difficult for them. So, for example, in the case of a will, whether you know about your estate really comes into your ability to give proper instructions and informed instructions. And so Pete would have to have a sort of general understanding that if they didn't know what their estate was worth, it might be a bit tricky for them to be able to make a will in certain types of terms. I've also put at number 4, a point that I think is really important to remember in court of protection work, and sometimes I think it can be forgotten by lawyers and some judges as well. But I like the way that Hayden put this, and he said similar things in other cases that he's determined. He said, the role of this court is to protect and promote human autonomy, not to repress it with misconceived paternalism. A life wrapped in cotton wool is a restricted and diminished one. I think that's quite a powerful statement to make. And I felt that it was important to make that when I reflected on my experience in other cases where I had come to these cases after the civil litigations. So usually when there's a statutory will that needs to be dealt with, or advice on property or something like that. And these decisions had been made by people before the deputy were appointed, usually a clinician, or the actual litigation firm, who had just made a blanket decision not to tell P. And they had done that without any real investigation about the risks, their understanding, the benefits, and things like that. And it's simple information, but it's something that for someone not to know about is actually quite an intrusion into their autonomy. Then if Pete does lack capacity to make the request for their information, then of course you move on to a best interest decision. And one of the issues in this case was, is the deputy able to make that decision? Or in other words, does that decision come within the authority conferred by the terms of the standard Property and Affairs Order? There was some discussion about this. We were concerned that in cases like this, where there is the potential for harm, that it would trespass into a welfare or health jurisdiction. So you might have, and I've had cases where he wants to know, and the deputy says, no, I'm not telling you. And then they threaten to harm themselves. I've seen that. Or I've also seen a case where the deputy did tell P, and P then made repeated requests for unreasonable items. So guitars signed by singers, things like that. And then eventually the deputy put their foot down, and that led to a catastrophic breakdown in P's care regime to the extent that they were then detained. So that argument was born out of our respective experiences and practice of seeing it go horribly wrong if the decision is maybe not the right one. But Hayden said, and I understand why he says that the starting point is that the decision comes within your authority. And I think that is right, because you might have, for example, a deputy for somebody in a care home who comes into some inheritance, maybe wins the lottery, something like that, and or just wants to know what their house is sold for, things like that. Obviously, it's for a deputy to be able, within their authority, to tell that person those things. But there will be cases where it's appropriate to actually go back to the COP to, I suppose, sanction your best interest analysis in your decision. And that's why Hayden said this. Precisely because the Court of Protection is such a highly fact-sensitive jurisdiction, it is perfectly conceivable that what might appear on the surface to be a property and affairs issue is on a proper construction nothing of the kind, and truly a welfare issue. In these cases, an application can be made and a deputy's authority extended where appropriate. So he's leaving the door quite open. He is saying that you have the power to make it, but it may be a case where it does trespass into health and welfare, in which case you should be thinking about making an application. He also dealt with the need to obtain P's wishes and feelings very briefly in the judgment, and this is in the context of him discussing the DXW case. In DXW, it appears from the judgment that no one had really made an attempt to get P's wishes and feelings on the issue before the court, and the judge was not critical of that, but essentially said, in most cases, there should be an attempt to get P's wishes and feelings, as there should be in any court of protection case. But that is qualified somewhat by the very fact that if a deputy seeks those wishes and feelings, it may have the potential, or it could undermine the protections that are actually being sought for P. So what's being said there is that you should get P's wishes and feelings, but if you think that that's going to harm P, or it's going to expose them to any financial expectation or anything like that, then you may feel it's appropriate not to obtain those wishes and feelings, and that is permissible. Then the judge dealt with the official solicitor's, not argument, but the point they raised, or she raised, about lasting power of attorneys. And this is a really important point, because it's a different way of dealing with LPAs to deputyships. The point was made by the official solicitor that a deputy is a creature of statute. By contrast, an attorney is an agent appointed on behalf of their fiduciary. And if the donor, if the attorney decides for whatever reason not to tell the donor about their estate despite a request, then it puts them in conflict with their agent or donor. And the court concluded here that that was right, and that if an attorney, for whatever reason, declines to tell the donor after they've asked for that information, then they need to get the authority of the Court of Protection. So that's a difference that you do need to be aware of from this case. So those are the kind of key principles of the decision. And moving to the decision in the specific cases, firstly dealing with CK, the judge concluded that she lacks capacity to decide whether to request the information from the deputy. And the reasons for that were really about her lack of insight. So CK demonstrated that she was pretty good with numbers. She is involved at a relatively low level, but still a sophisticated level, of budgeting with the deputy, and she has expressed a desire to want to get involved with that more as she gets older and more experienced. And quite remarkably, she managed to effectively guess the extent of the settlement. I'm not quite sure how, but she had a very accurate guess of what the value of the settlement was. On the other hand, however, she lacked insight into the actions of others. And there had been evidence that she'd had relationships where men had taken advantage of her financially. She had, as many individuals, like CK do, entered into phone subscriptions and then got themselves into debt. And she had put herself at risk of financial abuse. And this led Hayden to conclude that her primary area of deficiency is her inability to recognise her own vulnerability. Notwithstanding that decision on capacity, the judge went on to decide that it's in her best interest to be provided with the information. And these were the reasons why. The first, and I think one of the magnetic factors, is that she has a family that are a very strong protective factor for her. She lives with her family, and they're very invested in her welfare and her care. Secondly, that she'd already pretty much guessed the value of the settlement anyway. So I suppose if there were any damage to be done, it had already been achieved. I think a key factor was that she had already been assessed as having capacity to make a relatively simple will. And without the information, or the value being confirmed to her, it's not impossible to make a will, I think, but it becomes pretty difficult, especially if you're thinking about carving it up and making legacies to individuals. So the judge agreed with our submission that it would be a serious intrusion into her autonomy if she weren't then able to go on to make a capacitous decision to make a will. Also, that the involvement of the deputy provides a protective factor. Well, that would be in most cases, or in all cases, where you have a professional deputy, and that knowledge of the settlement in her specific circumstances was unlikely to escalate her vulnerability. In a different set of circumstances, that may change. So the point here is that these are factors that are specific to CK. In a different case, the outcome may well be different, as it was with NJ. So the judge found that she lacked capacity to make the request for her information. Unlike CK, NJ have profound difficulties with understanding numbers, even basic numbers. She had extensive mental health challenges, and which had resulted in her being detained twice under the Mental Health Act. She was able to understand that she didn't want certain people to find out, but she couldn't then take that second step of identifying why. So specifically, the risk was from her brother, who is a heroin addict, and she understood that she didn't want him to know, but she couldn't understand why she didn't want him to know. And the judge then went on to find that it wasn't in NJ's best interest to be told the information at this stage. And I just pause there to say that these decisions that may be made are not fixed necessarily. A decision may be made at one stage, but then circumstances change such that the decision might be difficult. But the factors here were that there was a history of extensive financial abuse by the brother, which made her quite strikingly vulnerable to exploitation. Importantly, she wouldn't be able to understand the settlement information. So it was likely to cause her distress or anxiety, which wasn't the position with CK. In actual fact, CK was then, as I said, able to then go on to use that information to make decisions about making a will, to become more involved in investment decisions with the deputy. And also an important point with NJ is that the deputy was really concerned about managing her expectations if she knew about the settlement. She knew that she had got a lot of money and had, as lots of young people might do in those circumstances, said, well, I've paid for this and I've paid for that. And so we were concerned that it would cause a potential breakdown in her care arrangements. And also the judge found that she was unlikely to have capacity to make a will, so it was unlikely to prevent her from making any capacitous decisions. So those are the outcomes in this particular case. Here I just set out a summary of what I think are some practice points. I'm sure there are more to add to this, so I'd be interested to know what any of you think of them. I think it's really important to make people in the civil litigation claim aware of this decision, because it has an impact on what the civil litigation firm is doing about this issue. Because as I say, I've seen firms that make this decision unilaterally without any lawful basis to do that. But also it affects the expert evidence in the deputy cost claim. So because this is not a decision that a deputy is able to make without considering the capacity on that specific domain, there might be a need to consider in a case that there's a foreseeable risk of an application being made. So what I'm saying is that there would need to be costs provided for in the expert deputy report in the civil claim. So that's where cases are going to be a bit tricky. Secondly, if you have been approaching this as, well, I've got my deputy order, so it's up to me to make this decision without actually expressly considering P's capacity on this decision, then you need to go back and have a think about whether that's actually the right outcome. And so you might need to, where relevant, think about having P assessed. If they are, I think, expressing a desire to know about the settlement. And this is why the capacity question is important, because if they're not asking about it, then it's not necessarily a live issue. If they do lack capacity, then you as deputy can make that decision yourself. There may be decisions where it's so clear-cut, you don't need any external assistance. There may be cases where you actually feel it's appropriate to get a report from the case manager or for their treating clinician or a neuropsychologist. That's certainly the evidence that was before the court in this case. If, however, it's a more challenging case, then it's open to you to make an application to the COP to seek that sanctioning of your best interest decision. And I think the reality is those cases where there is a disagreement between family members that can't be resolved, or P has got really quite firm wishes and feelings, and your decision is then having a knock-on effect, maybe with the care regime or with the family relations. And sometimes deputies feel that if it's put to the court, they can say to P, well, it's not up to me, it's up to the judge. And that can then make P feel that it's not the deputy trying to control things. And that's usually quite helpful for a deputy to be able to say that to P. When you make, I suppose the question is, when is the timing of this application? I wondered whether it could be made at the approval hearing of the settlement. There are obvious benefits to that, is that it doesn't require further hearings. It deals with it more expeditiously. I think the downsides of that are the lawyers involved at that stage may not be COP specialists, so may not approach this in quite the same way that we would. The other alternative is when you are making your re-ACC applications once the settlement is finalised. If you think it's likely to be an issue at that stage, you could include it within those applications, or just as and when it becomes a live issue if P starts to make that request. Next, if you are a private client solicitor and you are advising on LPAs and drafting those LPAs, then you need to be aware of the difference in treatment of this issue. So attorneys and donors need to be advised about this when the LPA is being drafted, because it may well be the case that a donor wants to put something specifically in their LPA about it. And if an attorney does decide that they're not going to tell the donor about the information and the donor is asking for it, then they will need to make an application to the Court of Protection. So that's my whistle-stop tour of the case of PSG. I hope you found that useful. Sorry, I'm just having a look at the chat. Quick point on costs in litigation. Thanks, Sam. Because not fixed decision for all time, think about need for costs to cover more than one application should the position change in the future. The younger the P, the more likely this may be. Yes, entirely agree with that. And I think that's the point, that one of the points we were thinking in PSG is that when you are dealing with the expert report, the expert's got to think about all the things that could happen over the lifetime of P. So you've got to, as deputy, make a good guess about how likely this might occur. It may happen when they're 20, but then it might reoccur when they're 40. So I think Sam raises a point to make sure that there are sufficient costs included within the civil litigation claim to cover this issue being raised more than once. Okay, well, I'll leave it there given the time. There's my email. So if anybody has any questions, do feel free to get in touch with me as always. I'll circulate the slides too. So again, feel free to share those with your colleagues. But thank you very much for attending. Goodbye.